Hello, everybody, and welcome to History/Law Bite number 296, dated August the 6th, 2021. I'm Walter, your mobile historian and blue-collar scholar. Thanks for tuning in. This History/Law Bite is entitled Chancery in Maryland. Before we begin, I invite you to subscribe to my YouTube channel, Juarez Lee Shelton, M.A., as well as click the little notification bell immediately to the right of the red subscribe button. In doing so, you will receive notifications when I post new and exciting educational videos. Thanks in advance. Chancery, of course, is the additional or alternative name for equity jurisprudence, a unique area of the law that historically provided remedies for individuals when there was either an insufficient remedy in the common law or no remedy at all. Okay? Now, equity jurisprudence has its roots, of course, in England. Okay? And that, of course, transplanted itself to the American colonies. We focus in particular today on Maryland, my home, and one of the original American colonies. This particular video is entitled On Chancery in Maryland. All right, On Chancery in Maryland was one of my writings that was completed in May of 2018, and essentially here I'm just translating it over into video format. Okay, so Chancery, all right, or equity jurisdiction in Maryland, as I stated, has its origins in the state's British colonial period, which lasted from 1632 until 1776. Okay, Chancery provides equity or fairness to legal problems where there is no solution given by statutes or the common law in general. Okay, so the historical background behind equity, okay, like most of our legal structure here in Maryland, comes from England, as I mentioned before. Okay, there, the King's chief secretary, known as the Chancellor, hence Chancery, all right, handled cases which required a more personal touch, okay, than what the rigid letter of the law required, ladies and gentlemen, all right? Chancellors tended to be very learned in the law, okay, and that of the church as well, okay, and as such, the chancellor was often known as the keeper of the king's conscience. The chancellor provided equitable, okay, or fair remedies to the situations that came before him. And thus, logically, he was a very vital figure in the administration of justice in England. To bring a case to the chancellor, one likely, okay, had to either have had no remedy, okay, at common law, or a very insufficient remedy, okay. The styled name of Chancery Court is derived from the title Chancellor, which is not something you hear very much, in modern political references in the U.S. today, okay. But once upon a time, many U.S. states had this official, and some states still refer to their judges that deal with chancery or equity matters as chancellors, okay? So, like today, all right, Maryland chancery jurisdiction in early years covered most family law issues, probate, land division, as well as some corporate issues as well, all right? So its history began here in 1637, roughly, just 4 years after the Maryland colony was officially created, all right? That year, Cecilius Calvert, Lord Baltimore and proprietor of the Maryland colony, named the governor as the Chancellor of the colony to hear Chancery cases, ladies and gentlemen. The offices of Governor and Chancellor would be mutually joined until the adoption of the Maryland Constitution of 1776, which for the record was our first state constitution here. During the early years of Maryland, there was no legal distinction made between law and equity, all right? And the governor, as the chancellor, presided over both types of cases in the early provincial court, along with members of his council, okay? Charles Calvert would succeed Philip Calvert as the governor of Maryland in 1661. But Philip did in fact retain the office of chancellor, thus presiding over equity suits whenever Charles was unavailable. So to initiate an action at equity in Maryland, first, the law either typically failed to provide a remedy, or the remedy was insufficient for the resolution of the matter. If either was the case, one filed a complaint or injunction listing the grievances against a defendant who had a certain time to respond. The chancellor would subsequently issue his judgment or decree based on the evidence from both parties. So, this was real, folks, all right? The chancellor was a very real and authoritative figure in early Maryland. So due to the volume of chancery cases filed over the years, a separate clerk would ultimately be assigned to the Chancery Court in 1669, okay? And although the Chancery and provincial courts were officially separated in 1675, the membership of both judicial bodies was constituted of the governor and council for the next 20 years, okay? In 1694, all right, it was reformed to include the governor and 2 non-council members. For many years, as such, the Chancery Court sat as a panel of judges, all right? But when the law was amended in 1720, the membership was reduced to 1 jurist, the chancellor, okay, who was the governor of Maryland. With the advent of the Revolutionary War, all right, Maryland became one of many states to disallow dual office holding, okay? So with this, the Chancellor of Maryland, all right, became an entirely separate official, all right, from the governor, all right? And that was made effective by way of the 1776 Maryland Constitution, all right, our first state constitution, like I said. It didn't matter, however, as the chancellor would therefore be appointed by the governor, confirmed by the state senate, and would serve during good behavior, translated for life, all right? Accordingly, the equity proceedings specifically given to the chancellor by statute increased the authority, all right, of the Chancery Court to hear probate issues related to minors as well as to mentally challenged persons, okay? As time progressed, the gradual process to reunite law and equity began to take form, all right? Remember, everything happens in cycles, all right? So county courts in Maryland were given concurrent jurisdiction to hear chancery cases beginning in 1814 and soon took a leading role in their disposition. All right. With the adoption of the Maryland Constitution of 1851, the office of Chancellor was given another 3 years of life to eliminate its growing backlog of cases. During that time, no new filings were accepted with the court. And in 1853, all remaining cases of the Chancery Court were removed to the appropriate local courts in the counties and Baltimore City. and the office of Chancellor, and thus the High Court of Chancery, ceased to exist in Maryland on June 4th, 1854. So this brings us to the present day, all right? In Maryland, equity jurisdiction is still very much alive. It, of course, exists throughout the United States, all right? In all of the states in some form, all right? Though it is, with specific reference to Maryland, it is no longer performed specifically by distinct chancery or equity courts, all right? As law and equity have been officially blended in the state since 1854, all the state's trial courts have thus the authority, individualized authority, to exercise some equity powers along with their well-established law jurisdiction. All right, so all the state's trial courts have some sort of equity jurisdiction as well, all right, as law and equity are blended in this state. So we don't have separate equity courts, all right? So we'll start with the district courts. Okay, in Maryland, the district courts are limited jurisdiction courts, all right? And they exercise equity power whenever their judges issue jurisdictional writs, injunctions, possibly specific performance issues, domestic violence peace orders, and restraining orders, folks, okay? So that's the district court. Immediately above the district courts are our circuit courts, okay? These are the state's trial courts, major trial courts of general jurisdiction, all right? And in the circuit courts, their judges, like district court judges, have the power to issue injunctions, certain writs, and their own realm of equity jurisdiction in handling family law cases and housing foreclosures, okay? The circuit courts also employ general equity magistrates and magistrates in chancery solely for handling this type of jurisdiction in the appropriate circumstances involved, okay? Last but certainly not least, we have the orphans courts, all right, which are very limited jurisdiction courts responsible for disposing of probate matters, all right, which of course involves wills, estates, and trusts. These courts are essentially equity courts in their entirety, folks, based on the subject matter jurisdiction that they have, all right? The fair distribution of a decedent's estate and other particulars were matters historically handled by chancery courts, ladies and gentlemen. And, you know, essentially with respect to probate, only the name of the court has changed, okay? Not the matters that it handles, all right? So probate was traditionally an equity matter, all right? The fair distribution of a decedent's estate, all right? Like I said, only the name has changed, all right? The type of matters discussed have remained constant, and the type of matters handled by the court remain constant, okay? So to conclude, equity/chancery jurisdiction in Maryland has existed since the birth of Maryland itself, for all intents and purposes. Though it has gone through phases of being united with law, separated, and then united once more, it has retained its distinct identity despite not always having distinct courts to handle its cases. So because of its necessity in handling certain types of legal disputes, equity remains a vital part of the legal structure in the state of Maryland, and because of it, persons retain the ability to have case-specific remedies, all right, for cases that the rigid laws do not provide the necessary remedies for, all right? So that is chancery in Maryland, ladies and gentlemen. If you have any questions or controversies, you can leave them down below and I'll be happy to answer them. If you learned something from this video or enjoyed it in any way, shape, or form, I know some of it is kind of dry if you're not interested in, the English common law and the derivatives of the common law, may not exactly found it very exciting. But if you appreciated the knowledge in any case, drop me a like. I would greatly appreciate that. And last but not least, if you've not subscribed to my YouTube channel, please do so now. All right. I would appreciate that more than you will ever know. So I thank you again so much for listening to my video, Chancery in Maryland, which was one of my writings from a few years ago. All right. And of course, in making the video, I did a little bit of ad-libbing as well. So I had to make it a little more exciting because I understand everybody might not be exceptionally excited about the subject at hand. So again, thanks again for listening. Take care. Stay safe out there. And I'll talk to you at the next bite. Peace.